You're the one selling the property. You, the homeowner. Not the trustee under the deed of trust. It's you, the homeowner. 580 deed protection springs into existence when who sells the property? The trustee. The trustee under the deed of trust. The trustee is usually be a title company. It's some company selected by the bank. It will identify that trustee on the notice of default and on the notice of sale. It's going to be some third-party entity. They're playing the role of trustee. It's when they sell the property that that 580D protection springs into existence. If you sell the property, then 580D protection does not spring into existence. You with me on that? That's important to know that when we start talking about alternatives. Okay, next slide. Okay, just by a show of hands, how many people have more than one loan on their property? Don't be shy. We've all had more than one loan on our property from time to time. Yeah, okay, a good number of people. So the question becomes, how do you determine liability when you've got your obligation to pay when you've got multiple loans on the property? That's a good question. Easy question though. Because common sense here again goes a long way. These are breach of contract actions. If you've got, to illustrate, I just randomly selected lender A, B, and C. So we're going to use in my illustration we're going to use lenders A, B, and C, 3 different lenders. And for purposes of our illustration, lender A, B, and C are 3 different lenders. They're not the same lender. They're 3 different lenders. That's why I give them different letters. Okay? So, if you have 3 loans on your property with lenders A, B, and C, and you don't pay, and assuming that they can sue you, you'd be facing 3 different lawsuits. 3 different lawsuits for 3 different breaches of contract. 3 different contracts. That's how you have to look at this. When you want to figure out your obligation to pay having to do with your house, you have to look at each contract encumbering your house. Each loan. And for each loan, you have to ask yourself, do I have to pay? Are there exceptions to the rule that will exonerate me from having to pay on that particular loan? And I will tell you, it starts getting a little tricky when you got multiple loans, and especially in a foreclosure setting. But I'm going to go through that with you real quick. Okay. We got two contracts, deed of trust and a loan. Okay, the loan deals with the money, the deed of trust deals with the property. So the deed of trust deals with a lien on the property. Now, I say, what do I mean by first, second, and third? You guys ever hear? You've heard those terms before, but once upon a time, I didn't know what those meant. Somebody had to sit down and explain it to me. I'm going to explain it to you. The easiest way I can explain it is think of it this way. Your house sells at a foreclosure sale. Think of yourself being in a high school gymnasium on the middle of a basketball court, and there's a pile of cash. That pile of cash represents the sales proceeds from your house. Then standing in a line in front of that pile of cash are 3 gentlemen wearing 3-piece suits, each with a briefcase. The guy that's first in line, his name is lender A. The guy that's second in line is lender B, and the guy in third in line is lender C. Lender A, who's first in line, he gets to walk up to the pile of cash, open up his briefcase, and start funneling cash into his briefcase. He will do that until one of 2 things happen. His briefcase is full, or the pile of cash is gone. Now let's assume his briefcase gets full. If his briefcase gets full, he's going to close his briefcase. He's going to say thank you very much to the other guys in line. He's going to wish them a good day, and he's going to leave the gymnasium. Then lender B, guy second in line, he's going to walk up to the pile of cash. He's going to open up his briefcase, and he's going to start funneling it into his briefcase. And here again, he's going to do that until one of two things happen. His briefcase is full, or the pile of cash is gone. That process will continue until one of two things happen. Everybody's briefcases are full, or the pile of cash is gone. What happens if the pile of cash is gone and you still got guys standing in line? That's what I call unfortunate. That's what I call unfortunate. Because whoever's still left standing in line has a claim against you for that money. And you have to ask yourself the question, do I have to pay him? And the answer is going to vary from person to person, from household to household. Some people will have purchase money protection, some people won't. Some people will be protected under 580D of the Code of Civil Procedure, some people won't. Some people will have to pay it, some people won't. And here again, you may say that's not fair. But again, I remind you what our parents told us as we're growing up. Life's not fair. Okay, so now when I talk about first, second, and third position, that's what we're talking about. You're going to hear me use the term junior and senior encumbrances. When you hear somebody talk about a senior encumbrance, they're talking about what position they occupy in this line. The guy that's first in line, he is the most senior encumbrance. The guy that's third in line is the most junior. So C is junior to B and A. A is senior to B and C. B is junior to A, but B is also senior to C. See that? Kind of makes sense. And here's the rule that I want you to understand, and it affects the lien on the property under the deed of trust, okay? Here's what I want you to understand. In a foreclosure, all junior lien holders lose their liens against the property. All senior lien holders retain their lien. All senior lien holders retain their lien. Junior lien holders lose their lien. Senior lien holders retain their lien. That's important to know, because if the lender loses his collateral and still wants his money, what does he have left? What did I say a lender could do to get their money? Sue or repossess. If the lender loses his collateral, can he still repossess? No. He's lost his collateral. So if he can no longer repossess, what has he got left? Sue. Sue. That's all he's got left if he wants his money. That's all he's got left. Okay, so it's important then to know what happens in a foreclosure. Let's assume lender A does the foreclosing. What happens to the collateral for lender B and lender C? What's that? They lose it, right? If lender A forecloses, they're the senior lien holder. All junior lien holders lose their collateral. So if lender B and lender C lose their collateral, what option does lender B and lender C have to get their money? Sue. They get to sue. Okay. Now, then the question becomes, do you have to pay lender B or lender C? And what is it you're going to look to for guidance as to whether or not you're going to have to pay? You're going to look to California Code of Civil Procedure Section 580B and 580D. Purchase money and non-judicial foreclosure. Well, I don't have a purchase money. Well, that's unfortunate. Because now you